Hi, friends. Come on in. Type in freedom now. We have some breaking important news to discuss today involving news from the U.S. Supreme Court. And really, more importantly, what do you do next? Because if you've been following McBean immigration law for any amount of time, you will know that we're all about solutions, strategies, and getting folks on the right track. So, in today's live session, we're going to talk about, yes, the breaking bad news out of the U.S. Supreme Court involving the decision for Haitian TPS and Syrian TPS. However, I'm also going to spend the bulk of this time talking about strategies and what folks need to really be thinking about and doing in this very moment. So come on in and type in freedom now. Freedom now. Let's get our energy level up and type in freedom now. And we're going to focus on solutions in this one. I know that a lot of people today are devastated. A lot of people are really down about this decision to end TPS or to allow the Trump administration to end TPS for Syrians and Haitians. But for some people, they have a way forward. This is not the end of the road for them. So as you're joining this live session, do me the favor and share this live session with others, particularly those in the Haitian and Syrian communities, and even anyone actually from any of the other countries that where TPS came to an end. Share this with them because the information in this live session, friends, is transferable. Okay, transferable for anyone who had TPS and the status has ended or coming to an end. Type in freedom now. I'm Latoya McBean Pompey, an immigration lawyer in New York. We work with clients nationwide at McBean Law. You may reach out to us at 914-898-9488 or at info through email at info@mcbeanlaw.com. Well, someone is asking, what is TPS? TPS is temporary protected status, and it was created by Congress to allow individuals, foreign nationals from countries that have experienced some devastating natural events or even war. It's a war-torn country, but some major upheaval has happened in that country, and it allows those nationals who are here in the United States to be protected from deportation, to go back to that country where there's so much devastation. It protects them from being sent back to that country, and it also allows them to have lawful status here and be able to work. Now, TPS for Haiti in particular has been around since 2010, since that big devastating earthquake in Haiti. And this Trump administration, they tried to end things during Trump 1.0, and they were unsuccessful then. And as soon as they came back into power, they went right at it with attempts to end TPS for pretty much almost all countries, with the exception of four. And they've been very successful, and the U.S. Supreme Court handed them a huge victory today. Now, in light of this decision, which was a 6-3 decision by the court, with the majority opinion written by Justice Alito, who said that the comments that the administration made about Haitians over the past year and a half, those comments were not overtly racist, and those comments, they don't really mean that much from the standpoint of motivating the government to end TPS for Haiti. Anyway, so that's in that opinion. What we're going to do next is, by the way, I'm pulling up the opinion here on McBean Immigration TV on YouTube and on Facebook. What we're going to do next, friends, is we're going to talk about what should you do? What should you do? If you are Haitian or Syrian or from any of the other countries that Venezuelan and other countries where TPS has come to an end, what should you do? This is my framework here for how you really need to think about this issue and steps, practical steps that you can take moving forward. If you're joining on TikTok, give me a double tap the screen and follow. If you're joining on Instagram, thank you for being here. But if you'd like to see the outline that I have here in front of me, head over to YouTube at McBean Immigration TV, where you can watch this and see the notes here. And I'm going to try to, let's get this off the screen so that we're not distracted. Okay, so TPS has ended. Now what? Now what? Well, the first set of people who this will impact are those who are not in removal. If you're not in deportation proceedings, you have due process rights. You're not subjected to expedited removal, which is a fast track deportation. So do not think that, oh, they're going to pick you up tomorrow or next week in Springfield, Ohio, or wherever you are, Brooklyn, New York, on Flatbush Avenue. They're going to pick you up and then they're going to put you on a plane back to Haiti. No, you're not subjected to expedited fast track removal. If you're not in removal, you should expect that a notice to appear to in immigration court might be sent to your home. Okay, a notice to appear. It starts the removal process, and if you do get this notice to appear, friends, do not miss any hearing. Do not miss a hearing. Your fight has you know you're it's just a fight. It's just a fight in immigration court. And if you have a case pending at uscis, such as an I-130, an I-589, which is an asylum case, or an I-485 adjustment of status case, use this defense in immigration court. It's shifting. What's happening here is your case is gonna be split up, right, between USCIS and the immigration court system. So whatever track you're on, so to speak, or road that you're on for lawful status through USCIS, you could still continue that process and take that case also before the immigration judge. Now, your lawyer will probably try to get your case dismissed in court, or sometimes or seek an adjournment, or ask the court to rule on your application right there in court, so that you could get your relief from that immigration judge. So that is a possibility for some people. If you have an adjustment of status case pending, however, at USCIS, you should expect that USCIS will administratively close that case unless you're an arriving alien, in which case USCIS can make a decision actually on that adjustment of status case, and then you can try to then dismiss your removal case. So just to repeat this real quickly, if you're not in removal, a notice to appear is likely to be sent to the home, and you can make your argument in court. If you have a case pending at USCIS, the court will be notified of that, and your lawyer can seek to get your case dismissed, or even ask the court to rule on that application. It just really depends on what the application is. You might also qualify for other relief in immigration court, which is particularly cancellation of removal. Cancellation of removal is it's a process that will allow some people who have been here for at least 10 years to and they have a certain relative, like a U.S. citizen or a green card holder spouse, child or parent, or a green card holder parent. It allows you to make an argument to the judge that you need to remain in the United States. This person needs you. They're going to suffer some real hardship if you're deported. They need you here in America with them. So for some people, actually, going into the removal system will help you to ultimately get a green card if you have a good cancellation of removal case, okay? And the judge rules on it. It's a tough case to win. The data on this one is not amazing, but it is it is still a very good process. So keep that in mind. Also, you should get screened for asylum. Okay, for some people, asylum might be that next transition. It's not the default transition for most people, but for some, transition to be screened for asylum so that you could transition to an asylum case, or you could be screened for a family-based petition if you're married to a U.S. citizen or have parents who are U.S. citizens, or an adult U.S. citizen, son or daughter, or even if you have a green card holder parent or a spouse, you might be able to start an I-130 family-based process. You should also be screened for humanitarian applications like the U visa, T visa, or VAWA, which is a process for victims of these processes that I've discussed here. U and T, those are really for individuals who have been victims of like a crime or trafficking. And it also includes like labor, trafficking, and VAWA, which is domestic violence. Be screened, friends. You never know where you might land. Okay. Now, also, again, I'm speaking about those who are not in removal. What the options could very well be for you to keep to transition to lawful status. Consular processing. Now, depending on how you entered the United States, you might be able to end your process overseas. But the big issue and problem today, unfortunately, which is why this is in red, is that the government is trying to squeeze Haitians in particular and other nationals from the 39 travel ban countries, which means that if you were to leave the United States for a consular process to finish up and get a green card, the embassy at this time would not issue a visa to you so that you could return to the United States, because there's a travel ban in place. There's also a ban on a pause on immigrant visas at this time for certain countries. So I caution you with respect to consular processing. But once all of this passes, you might be able to leave and finish your process overseas. So it is still a good idea to start a process, get something moving. You have due process rights. You're not subjected to fast track deportation. Okay, so keep that in mind. The next category of individuals are those who are in removal, but no removal order has been issued against you yet. No removal order has been issued. You likewise have due process rights. You're not subjected to fast track or expedited removal. But again, you need to attend every hearing, because if you do not attend every hearing, the immigration judge will issue a removal order against you in your absence. So attend every hearing. Now, you also need to ensure that an application has been filed in court. What is on file for you in court? If you do not have an application pending before the court for the judge to decide on, the judge can issue a removal order against you just like that very quickly. So ensure that there's some application that you have credibly filed with the immigration court so that the judge does not issue a removal order against you. Remember, in court, if you're in removal, you have a right to appeal the decision. Okay, if the judge issues a removal order against you, you have the right to appeal that decision. You also have the right to seek help from the federal court system, okay, through the petition for review process. You also have the right to ask the Supreme Court to intervene, okay, if you have a good strong case and it goes all the way up. But you should certainly, along the way in removal, expect that the government attorney will push back and seek to end your removal case. with a removal order. That's their number one strategy, particularly for this for individuals who are transitioning from TPS. So again, you're in removal, but no removal order has been issued against you. You have due process rights to go all the way to the end and appeal a decision if the judge issues a removal order against you, and keep an application on file with the court. In the removal system, for very many people, does not move very quickly. Okay. Um, yes, we're hearing now about some crazy things that are happening in the removal system. And I even talked about some of those crazy things on Monday. But for the vast majority of individuals, it tends to be a slow process. But pay attention to your hearing date, because the courts are changing the dates on people just like that, and adequate notice of new hearing dates are really not being provided by the court system at this time. So really stay on top of things. Now, what about if a removal order has already been issued against you and you had TPS? A removal order was issued against you maybe in 2012, or 2013, and you're still here. You have and TPS has ended. You have very limited rights, okay? Limited rights, because you remember you had already gone through the removal system, all right, before the judge, and the judge made a decision on your case. So your rights at this point are limited, but you still have rights, and you even still have constitutional rights. But you should consult with an attorney to determine what package of legal services are available to you in the event that you're detained, including an emergency motion for stay, to stay removal, and maybe even habeas, and then a plan of action for maybe how to bring you back to the United States in the event you're deported. So, friend, this is how I'd like for you in this community that I reach through the work that we're doing through McBean Immigration TV. I want you to think about it from this standpoint. Am I in removal? Right? The first point is really, I'm not in removal. Now what? Okay, I am in removal. I have here a hearing date coming up. What's next? And then, oh, removal has ended for me. It ended years ago. I have a removal order. Now what? Action steps. Okay. Now I'm going to jump off the screen and try to answer some of your questions. Again, if you're now joining today, the U.S. Supreme Court gave a couple of immigration rulings. Okay. The first one, I'm not going to get into the second one and this one, but the main one truly is allowing the Trump administration to end TPS, temporary protected status, for 350,000 Haitians and 6,000 Syrians. This is a very, very big decision, big deal. And as a matter of fact, the New York Times today said the Supreme Court expands Trump's power over immigration. The court handed President Trump victories in his push to rescind deportation protections for hundreds of thousands of people and turn away migrants at the southern border. And that has to do with asylum, individuals appearing at the border seeking asylum. The Trump administration was handed a victory with respect to how they could manage that issue as well. Now, what questions do you have for me as I transition to a brief Q&A? And thank you also for joining today, and share this with others. Do share this with others. Okay. Let's see. Thank you, guys. Double tap the screen. I know that people are concerned about their work permit in light of today's decision, and and I saw, yeah, people are concerned, of course, about their work permit. Um, you know, think about the options that I've shared with you in this one, okay? If you have a way of transitioning to another application type that would allow you to get a work permit, be screened for another application type if you have such an option. Um, let's go back up here. Thank you, guys. Let's start with McBean Immigration TV. Okay, so if a TPS holder got married, could they stay in the United States? Possibly, yes, possibly, through a marriage-based process. That's under the family-based system, so that could be a great way to stay here. And so, if an individual transitions to a marriage-based case and USCIS then places that individual in removal, it doesn't mean that everything's over for you. Okay, you still have the right and capability of seeing that marriage-based process to the end. It's just that now your case is going to be split in two, so to speak, but with a removal track and a USCIS track. Okay. Hi there. Good question. Thank you for that. Um, Someone says that our toll-free line is not working. I'm trying to reach you from Nigeria. Um, okay, so it should be working. We have an 800 number, and we also have WhatsApp capabilities. You'll find our WhatsApp number on McBeanlaw.com so that you could reach us via WhatsApp as well. Okay, thank you. All right. Um, Would it be, can you educate me here? Would it be a hurdle for these folks to file for asylum, being that they pass the 1 year deadline? Um, TPS holders can transition to asylum if eligible, of course. If eligible, they can transition, and they would not, in some cases, be penalized for a late filing. There's a rule that would allow some TPS holders who qualify, of course, to make an argument that, during the time that they had TPS, the government shouldn't hold it against them, so to speak, with respect to the late filing. One of my colleagues here, who is a Haitian, a Creole speaking attorney, was discussing that option with me not too long ago, actually. So for some people, yes, they can transition into with an asylum case. Okay, so keep that in mind. Freedom now, guys. Freedom now. What if the person has a pending I-130 since 2025 for Haiti? So it's possible, I believe, actually, strongly believe that the case was paused or held up under the adjudication hold at USCIS, that the Dorcas case most recently vacated. Um, so with your I-130, you're in a very good position. Okay, TPS, the Trump administration is ending this. So and thanks to the Supreme Court. So now you have your I-130. Do you have a remove, or have you been in the removal system? Do you have a removal order? If not, keep going, keep going. With respect to your I-130, as far as you could possibly go with that. But if the government then issues a notice to appear in immigration court, not to worry, you still have a way forward. Your I-130 can still be adjudicated by USCIS, but now, your case gets a little trickier and complicated because of the removal case, but it could still work out for you. It's not the end of the road for you. Okay. For many of you who are watching and in this situation, you're going to really see now the inner workings of this real complex immigration system that we have. But you can get through it. That's the point of today's show. You can get through this. Okay. Um, I have a super chat question here from Teddy. What if a person has a pendant I-130 from her son? Oh, that's you. This is, I think, pendant I-130 from her son since 2025 for Haiti with a final removal order, the person has check-in every year with immigration. So this checking in every year is through ICE. It's with ICE, I should say. So this person is under an order of supervision and has a removal order. Now, the I-130 can, USCIS can make that decision to approve your I-130. The next big push for you would be to reopen that removal case, if at all possible. It depends on what's going on, really. Under this administration, it's very difficult you will not be able to go to ICE for their assistance to join with reopening that case. You can still, however, submit a motion to reopen the case with the Board of Immigration Appeals and allow them to be able to make that decision about whether to reopen your case or not. But reopening your case is going to be really critical to you get into the finish line. The other inquiry that I think needs mentioning here is, well, how did you enter the United States as well? Because I don't know whether you'll be successful with adjusting your status through your son or whether you would need to finish your process at a U.S. embassy. So there's quite a bit there to consider. Okay, quite a bit there to consider. All right. Let's go through Freedom Now. If you're now joining today's live session, I'm speaking about the breaking news that came out this morning from the U.S. Supreme Court, granting or giving the Trump administration the ability to end TPS for hundreds of thousands of Haitians and 6,000 Syrians. And my colleague shared with me just a little while ago that TPS, that NPR, he pulled the source from NPR that only four countries currently have TPS or in good standing, so to speak, with regard to their TPS. El Salvador, Lebanon, Sudan, and Ukraine. Okay. Freedom Now. Thank you. Freedom Now. If anyone is in removal, let's go. Freedom Now. Freedom Now. So someone says here, pay more attention to plaintiff round 3. You should also pay attention to your emails to know what we're saying to you if you're in round 3. Okay, because we have been emailing and updating everyone. So pay attention to your email. Okay, thank you. Freedom Now, guys. Let's go. Let's go down a little bit. What's next for TPS for Haitians? What's next? That's what you might have missed it, Larson. You're going to need to catch the beginning of this later on today on McBean Immigration TV, where I went into a lot of details. But I do think that the Trump administration is motivated, highly, highly motivated to place more Haitians, in particular, in removal. They are really, that's clear. That's been a very strong agenda and push for them. Okay. Thank you very much for your organized outline, Latoya. Thank you so much, Rosie Rosisco, I think. Thank you. Okay, let's go down a little bit. If you're now joining, again, we're discussing the U.S. Supreme Court decision today, U.S. Supreme Court decision ending TPS for Haitians and Syrians. Thank you. Let's go down. Still waiting on marriage. What let's see, the big takeaway, you're very welcome, Jeff. Thank you very much. You're welcome. Let's see if I could answer a couple more questions before we go here today related to the topic. Thank you. Let's see. Okay. Um, Louise says, as a U.S. citizen, can I fill out the form I-130 for my Haitian husband? Yes, you can file for him despite all the craziness, despite the adjudication hold that you've been hearing so much about over the last several months, which has been vacated. You could still file for your Haitian spouse. You should definitely get an I-130 out there. Don't sit on it. Now is not the time to not file for your Haitian relative. If you'd like your Haitian relative to remain in the United States with you, get something going for him or her. Please do it. It does allow for a limited argument that this person has something going, and he or she has a right to see it through to the end. Okay. All right. Freedom now, freedom now, freedom now. Let's go to see if I can find more questions related to the topic. Can Congress make changes with regard to this issue? Um, Congress has set TPS in place, I think in 1990, many years ago, and this is not something that we can expect them to touch to assist. On the House side, a couple of months ago, I think it was, the House passed legislation to keep TPS in place for Haitians, but the Senate hasn't done anything with that. So Congress is not likely to come in here and save the day, unfortunately. Okay. My husband is still in Haiti. He is still in Haiti. My answer is still the same. File an I-130 for him, get that process moving, get it started, and let USCIS make its decision on that case. Okay, let's go. Let's see. Uh, let's see. What I'm going to do is we're going to wrap up. Do you think the midterms will help Haiti? I do not. I do not. I think that I think the administration was weighed in for today. They were weighed in for this decision, obviously. We saw them, they were ready, I think back in February in Springfield, is it Springfield, Ohio? They were ready months ago when the end date for TPS for Haitians was approaching, and then a judge stopped it temporarily. All of this, a lot of the movement that you see on the district court level tends to be temporary as the administration appeal these decisions. And the next big decision, obviously, that we're all waiting on is with regard to birthright citizenship. That is going to be a very, very big one. We're still waiting on that one to come out from the U.S. Supreme Court. Okay, guys, I'm going to jump off here. Thank you so much for being with me. If you did not see the beginning with my outline of what you should do, action steps, tips, and things to think about, and how to get your status more secure if you are Haitian or Syrian and TPS has come to an end for you, watch YouTube, watch this McBean Immigration TV session in the beginning where I covered some action steps for you. Thank you so much for joining me today, friends. I will see you in the next one. Bye-bye.